We begin the program in Nigeria, where the Governorship Election Petition Tribunal in Kaduna State has upheld the victory of Governor Sani. The tribunal dismissed the petition filed by the People's Democratic Party and its candidate, Mohammed, who challenged Governor Sani's victory in the March 18th election. The tribunal's majority decision stated that the preliminary notice was filed out of time, effectively deeming the petition abandoned. However, a dissenting judge believed the preliminary notice was properly filed and not abandoned. Joining me this evening for this discussion is Mohammed Saidu Etsu, a former APC National Chairmanship aspirant and a chieftain of the party. He joins from the nation's capital, Abuja. I also have Abubakar Kari, a political scientist, who joins us also from Abuja. Warm welcome to you, gentlemen, and thank you for joining me on the conversation.
Thank you very much for having me.
Now, I'd like to start with you, Mohammed Etsu. What specific legal and constitutional grounds did the governorship election petition sitting in Kaduna tribunal cite when dismissing the PDP's petition, particularly concerning the timing of the preliminary notice filing? And what do you make of this judgment?
I think first and foremost, the judges who give the verdict of the governorship election, the just concluded a tribunal case in Kaduna State, gave the wishes and the aspiration, the valid judgment of the wishes and aspiration of Kaduna people and the indigenes of Kaduna State. And in that judgment, you can see that APC and PDP, the judges gave a valid judgment in the sense that the preliminary motion filed by the PDP is out of time, and which makes the election stands.
Okay, so do you support the judgment?
Of course, because if you look at it, everything in everything has a process. And the PDP candidates or the lawyers of the PDP refused to do the needful by filing their processes very late and out of time. And in any organization, if you don't follow the process or due process of doing things, the end result will be a failure, and that's what actually reflects on that judgment. Now, it tells you that in the judgment, if PDP feels that they can appeal the judgment, APC also have a right to appeal the judgment, because if you file a petition out of time, what do you expect the judges to do? Should they accept those things that you fall out of time, or they should just do it the way you want it to be? And which doesn't work like that. Anything in the judiciary has its processes. Okay. And PDP failed to follow the due process in making their arrangement
and the consequences for that. Thank you very much, Mohammed Etsu. I'd like to bring in Abubakar Kari into the conversation. He joins us from the nation's capital, Abuja. Now, Abubakar, could you provide insights into the typical... I would like to bring in our second panelist on this conversation. Abubakar, can you hear me loud and clear?
Yes, very well, very well.
Okay. Could you kindly provide insights into the typical legal procedures and timelines for filing election petitions in Nigeria, and how the timing of the preliminary notice filing deviated from the norms? Do you think it's a germane enough reason to dismiss the PDP's petition?
Well, I've not been a lawyer and not been affiliated to any political party. I think I want to look at it from the point of view of an ordinary Nigerian who is closely monitoring political proceedings and so on. There are two or three things I would like to comment about. The issue of time or out of time, the judgment itself, and what it has tied in the public and the implication. Talking about time, I think it falls within the issue of technicality that some of us have really been concerned about. One of the major features of Nigerian electoral litigation, of course, is undue technicality. For God's sake, why should we be bothered more about time or out of time or no time and so on and so forth when the court admitted that the petitioner rightly submitted his own petition, his pleadings were okay, and so on and so forth. We will be more interested, as far as I'm concerned, about the merits or otherwise of the pleadings, the evidences and proofs adduced by the petitioner, and the reply to the pleadings by the respondent. That, as far as I'm concerned, should be of primary importance and not any other consideration, but I'm not a legal mind. That is on the one hand. And on the other hand, it is quite curious that this court, on the one hand, dismissed the entire case on the ground of that out of time, and yet went ahead and looked into the merit of the case. So what was the reason? Why do you look into the merit of a case that has already been dismissed? Why do you waste everybody's time? Because this is merely an academic exercise.
Exactly.
The issue has been dismissed, and yet the court claimed that it was respecting a Supreme Court decision. Well, even the Supreme Court, I think, cannot be said to be fair to the Nigerian people if it allows a case that appears not to be meritorious, yet it should be looked at. So that is another issue. Then the third issue, which is very, very important, this whole judgment, as far as I'm concerned, appears to be replete with ambiguity. And that is why it created so much confusion. For almost the whole day, nobody knew exactly what happened. People were interpreting the judgment differently. Partisanship took center stage. People were shocked and so on. Why a judgment, as far as I'm concerned, should be clear, should be precise, should be unambiguous, should be devoid of any vagueness of anything that will create confusion. But this particular created confusion. So that is my concern.
Okay. Thank you very much. Abubakar, I'd like to bring back Mohammed Etsu into the conversation and pick up from where Mohammed just left the conversation. He said, there was a lot of confusion following the announcement of the result. My question to you, Mohammed, is this. How common is it for election disputes to result in public confusion, as we saw yesterday in the case of conflicting media reports about Governor Sani's status? And what do you think led to such confusion? And some have suggested that it's because, this judgment was delivered via Zoom. What impact can such a confusion have on the political landscape, and how can we, in your own wisdom, avoid such occurrences in the future? Can you kindly unmute your device, Mohammed?
I think we should stop the issue of making the whole judgment as a confused judgment. The judgment, it's clear, and the judgment was given on the basis of processes, procedural. If you want to get admission into a university, you must purchase a form with a time lag. You must be admitted and required to pay so amount of money before you get into the institution. And if you can't be able to meet up, definitely your admission's going to be forfeited, or you take you take it further. You further your admission for another session. It's clear. What the court says here is that you didn't follow the processes. You didn't meet up with the time. Now, based on this fact, you doesn't even have a ground to even claim the mandate, because if you didn't follow the process, how can you go and claim the mandate of this election? But the judges again came out clearly and said, if we did this, if you get this right, I think this election should be reconducted based on this XYZ, based on this election that couldn't fail in this polling unit because of the different margin of
yeah,
votes.
but you do
Now,
understand that it wasn't a unanimous decision by the judges. There were conflicting, there were conflicting judgments by the judges. What's the import of that and significance of that?
Yes, the import of that is telling you that all the judges there were able to bring out what it should be and how it should be. But this first step that the petitioner missed has quashed everything that the judges want to do, because if they gave the judgment that the election is inconclusive and they forget about these technicalities, it's another problem. And if you look at most of our elections, our election petitions, you must follow a procedural rule before you can even get a judgment. But now what we are saying, both parties have a right to appeal this matter. Because if you feel that based on XYZ, your election is nullified, he can also tell you based on XYZ, you couldn't meet up with this arrangement, so that we can set the record straight for both or for the Nigerians, so that we can understand more and more things that is happening in our election petitions and our democracy.
Now, staying with you, Mohammed, how could political parties and candidates, learning from what we've witnessed, approach election disputes in the future to ensure they have a stronger case and they can avoid having their petitions deemed abandoned by the tribunal? What steps need to be taken, and also not wasting precious judicial time?
I think that judgment gave us an opportunity to understand how you can be able to file your petitions or challenge election results in courts. And it will give other people experience, because all this judgment is a landmark judgment that no politician or anyone that want to participate in our electoral processes should take for granted. If you are given an opportunity to file a petition, you should be able to get it right before you even discuss about the merit of the matter. Now, if you couldn't get it right, you can't even go there and discuss about the merit or getting the judgment. Now, it serves as an eye-opener to all the political parties and even the upcoming politicians to understand how our judiciary works. And it works with the guiding principles. And it have what it takes to understand what will give you an opportunity to claim your mandate in Court of Justice.
Thank you, Mohammed. I'd like to bring back Abubakar Kari into the conversation. Now, Abubakar, the electoral umpire following the conduct of the general elections we witnessed earlier this year has come under a lot of scrutiny. There's a lot of trust deficit with Nigerians and INEC. Now, in terms of public perception and trust in the electoral process, what challenges does this conflicting information and claims of victory from both the APC and the PDP pose for the integrity of the electoral process, and also the judiciary? Because it was, some newspapers took the wrong information and put it out there as fact.
Well, at the risk of holding brief for INEC, I don't think it is very fair to blame INEC for these confusions. I would rather blame our jurisprudence. I think we have been saying this over and again, we stakeholders in the electoral process, that Nigerian jurisprudence is quite strange. It places too much premium on technicality. And I think it is only in Nigeria that you throw away the merits of a matter at the altar of technicality. In other climes, in other democracies, these things are not done. Apart from the fact that electoral adjudication or petition are sui generis. Okay, that is their completely on their own, completely different from other kind of litigations. It also places too much burden on the petitioner to prove. And anytime somebody contests an election outcome in court, INEC automatically becomes a defendant, becomes a respondent. So INEC too is unduly overburdened by the fact that it has to come to defend how it conducted an election. And in most cases, INEC had to come and defend the malfeasances and iniquities and unwholesome activities of politicians and their supporters and political parties. So, as far as I'm concerned, we can only make progress if we go back to some of the recommendations of the Justice West panel, which attempted to lessen this burden on INEC and do away with some of these technicalities. Because we have seen how technicalities made all the difference in otherwise very, very good cases. The 2007 petition by Muhammad Buhari, for instance, against Umar Musa Yar'Adua, what decided the matter was their technicalities when the Nikidobi claimed that Buhari required a lorry lot of witnesses to come and prove cases. Even when Mike Ahamba provided so much evidences, but they were gypsy. Look at the case of Oji Uzokalu, for instance, where having been convicted, he was simply freed because, according to Supreme Court, that the person who read the judgment was no longer a judge of the Court of Appeal and so on. So this kind of jurisprudence is very, very strange. It will be very, very difficult for INEC to conduct free, fair, transparent, and credible elections if and when election petitions, election outcomes that are contested are simply thrown away because of technicality. We really have to critically and realistically look into our judicial process, adjudication process, our jurisprudence to ensure that those who genuinely have grievances, those who genuinely have things to say about conduct of election are allowed to ventilate their grievances without being unnecessarily trapped in the labyrinth of technicality.
Okay, thank you, Abubakar. Now, back to you, Mohammed Etsu. Could you provide an analysis of the potential consequences of the tribunal findings regarding the 22 polling units, particularly in relation to voter turnout and the margin of victory? What does this mean?
Yes, what does this mean is telling you that if we go by the merit of the judgment, you look at it that the vote count, the tally of the votes and the number of polling units that was cancelled for the election, it couldn't match up. Definitely there are going to be election. But if we're going to go back and to that election, is there an opportunity or for the PDP to get that vote to tally with the number of a gap that the APC has already? That's another thing. And that's why the consequence now is let the PDP understand that this judgment is an opportunity for them to go and prepare ahead, because it couldn't give them what they are looking for in these whole processes. And that's my take on these regards.
Now back to you, Abubakar Kari. How might allegations of corruption and irregularities, even unproven, impact the public's perception of Nigeria's electoral system? and the credibility of election results? Because, I mean, these days we've seen a plethora of petitions in courts, and it seems that, the courts are replacing INEC as the decision, as the body that announces winners of elections, because there's been so many petitions, right from the presidential election petition to petitions at the state level. So how might these allegations of corruption and irregularities, even if unproven, impact the public's perception of our electoral system?
Yeah, unfortunately, perception is reality according to a school of thought, and it is really not in the interest of the democratic process, the electoral process, and Nigeria in general, that the public are very, very skeptical about judiciary, particularly in terms of election litigation. As far as the court of public opinion is concerned, judges are simply not dispensing justice, but they are doing the opposite. And this is simply because there is no synergy, even, in terms of ruling by courts of concurrent jurisdiction. They make judicial pronouncements that contradict one another. Cases are supposed to be logically decided upon. Judicial precedent is supposed to apply everywhere. But a situation where cases that appear to be similar are subjected to different and contradicting pronouncements and rulings and judgments will only add up to the public skepticism and would only make the issue of accusations of corruption against the judiciary to be increasing. So for now, the reality is many Nigerians are of the view that some of these rulings and judgments do not make sense.
Okay, now staying with you, Abubakar, the queries and judgment aside, we've seen quite a lot of petitions, as I mentioned earlier. Is this as a result of lack of sportsmanship and on the part of some of our politicians? Are they bad losers? Or do you think some of these cases have legitimate grounds to be contested?
Yeah, I must admit that it is also part of our political culture. It is one of the unfortunate negative outcomes of our political culture that those who contest elections normally are not good sportsmen and women. But the judiciary also has a hand in this. This is because litigation, particularly electoral act litigation, has literally become a game of chance. People believe that if they reject the outcome and go to court, no matter how untenable their case is, they may succeed. So, but if the judiciary has been very, very straightforward, has been handing out judgment and rulings that make sense, people who clearly failed election will not even contemplate going to court. But now, findings have shown that people contest for election and deliberately expecting after INEC has pronounced the winner, it is not the end of the story. You also go to court. But sometimes it is also because of the failure of INEC to give us free, fair, and transparent election. So that is why the outcomes are contested. So for you to stop all these things, INEC must give us good elections. The judiciary should also give acceptable judgment. Otherwise, people will continue to go to court believing that it is a game of chance. No matter how absurd their pleadings are, they may succeed.
Mohammed, looking ahead, what key legal arguments and evidence should observers and the public watch out for in the event of an appeal? Abubakar, Kari just said the jurisprudence is highly dependent on technicalities. What should the public watch out for in the event of an appeal? And how much of a chance do you think the PDP has if this case goes all the way to the Supreme Court at, changing the pronouncement of the election tribunal, the Court of Appeal?
Yes, I think the public should watch out for the appellate courts on their own judgments so that they can be able to deduce and get some facts about the whole thing. And if you look at it, the way the doctor said it, our judiciary is on trial because people with these issues that are blooming up in our elections and election petitions, it's give people opportunity, even a weaker candidate, to participate in an election and at the end of the day claim a mandate in which has been overwhelmingly given to an individual. But in this judgment, I'm telling you that it's going to be a dead on arrival because what the lower court, that is the tribunal, gave as the final verdict on the judgment, it's going to replicate itself at the tribunal. Because if you look at so many instances, a lot of elections have been dismissed based on all this technicality, the way my prof have said it. And on this, it can't change anything, even at the upper court, because the foundation of the whole thing has been rubbished by the lawyers of the petitioners. Now, it could give them a chance to even claim it at the upper court because you couldn't do the needful from filing the matter at the tribunal, and you expected them to give you judgment based on your perception or the view of the judges that if it has been done on this way, you can get it. But you couldn't do the needful. And that's why I'm thinking that the PDP should rest on this matter and join hands with the government of Kaduna State to move the Kaduna forward because of what has been on ground and what has been said by the previous administration of APC and the current government putting the finishing touches on the legacies of the APC administration in the last 8 to 9 years, so that they could understand that if you are going to court, you should get prepared based on the rules of engagement. We are not saying that the judgment is entirely 100% perfect.
Yes.
But the procedure of participating in the petition, it's wrong. And that's what gave us the mandate. And that's what gave the governor of Kaduna State, distinguished Senator Obasani, the victory at the lower court. And even at the appeal court, if they challenge the petition at the appeal court, it's still going to get the same victory. It's still going to be 1 + 1 = 2. Now, what I'm saying and what my senior lecturer have said is clear. The electoral umpires and the judiciary must go back to drawing board and revisit a lot of issues that we've been facing in this, our democratic dispensation, so that going forward, we shouldn't have more challenges, because if people can go to court and get a mandate through these ways, it will give a weaker candidate more opportunity, and it will overload the court with a lot of petition in upcoming election, because people will feel that, let me go to court and get my mandate through this way because of failure of this so candidate.
Yeah, Abubakar did mention that earlier. Thank you, Mohammed, Etsu, and I'd like Abubakar to have the final say as we begin to wrap up conversation this evening on this topic. Now, Abubakar, we've seen quite a lot of petitions coming to the courts, and it's the duty of INEC to conduct and announce results. Moving forward, how do we develop our democracy to a way that, politicians call each other and, congratulate their opponents without having always to resort to the judiciary for final adjudication and, for clearance on who exactly the winner of elections are? What needs to be done to get us to that level?
Well, very simple. What we have always been saying, that all the parties in election and all stakeholders in the electoral process should do their work diligently. Political parties should conduct themselves very well, should conduct their primaries very well, devoid of rancor and crisis and violence, and they should be fair and just. INEC should prepare adequately, very adequately, should be neutral. Government should be funded adequately. There should be adequate preparation. Election should be conducted transparently so that outcomes of it could easily be acceptable to all parties. The judiciary in particular should dispense justice, no matter how else is got. Courts are supposed to be the last hope of the common man. That is what it should be. Now, public perception does not align with that time-tested marketing. So, judiciary has a lot of fence mending to do. It has a lot of convincing to do to the Nigerian people. The justice should really be blind. It shouldn't be something that has become a game of chance. And Nigerians, in particular, I think they even have a bigger role to play. Democracy is about participation. One of the kernels of democracy is public participation. The public should be interested in every stage of the electoral process. We should hold all institutions accountable. We should insist that the parties should conduct themselves very well. INEC should organize elections. The judiciary should dispense justice. In other words, we must not be indifferent. We must not be apathetic. We must not give up. Democracy is about participation. If you do that, gradually but surely we'll get there.
Thank you very much, Abubakar, Kari, and Mohammed, Saidu, Etsu, for your time and the conversation this evening. I do appreciate your contribution and your insight.
Thank you very much.
Thank you for having me.
You're welcome. You're watching the conversation in News Central Television. We'll go on a quick break. When we return, we'll switch gears to Burkina Faso, where the government has detained 4 officers after a thwarted coup attempt. Do stay with us. We'll be right back after this break.